Welcome to Beyond Bare Act. When does unauthorised access become a cybercrime? In Episode 3, Raya completed an electronic transaction. The law could recognise the electronic record. The platform could authenticate the transaction. The parties could form an agreement online. And, if a dispute arose, the digital evidence would have to be proved through the legally required route. But now the transaction has become an incident. Ria receives an alert for a login she does not recognise. Her recovery email has changed. A confidential scholarship document has been downloaded. Several records have been deleted. For 20 minutes, authorised students cannot enter the portal. The platform discovers something unsettling. The activity came through an account issued months earlier to Kabir, a support contractor whose engagement had ended. His login should have been disabled, but it still worked. Was this simply poor account management? Was it access without permission? If Kabir once had legitimate credentials, did that authority continue? Does copying information count as damage if the original file remains? And does every unauthorised act automatically become a crime? These questions matter whenever an employee exceeds a role, a former contractor retains access, a student enters a restricted system, an insider exports a database, malware disrupts a service, or an authorised user is deliberately locked out. The Information Technology Act answers them through two closely connected provisions. Section 43 identifies a group of computer-related acts and provides a civil route to compensation when they are performed without permission. Section 66 asks a further question. Was an act referred to in Section 43 performed dishonestly or fraudulently? Welcome back to Beyond Bare Act. In Episode 4, we examine unauthorised access, digital damage, and the line between a civil contravention and a criminal offence. Popular discussion often begins with one dramatic word: hacking. Section 43 begins somewhere more precise: permission. Its opening words address a person who acts without the permission of the owner or of another person who is in charge of a computer system, or computer network. That means our first task is not to decide whether the incident looks suspicious. It is to reconstruct the boundary of authority. Who owned or controlled the resource? Who could grant access? Which account or system was covered? What role was assigned? For what purpose? For how long? And what actions were permitted after entry? Imagine the platform as a building with several legal zones. Anyone may view its public webpage. Raya may enter her own student account. A support employee may reset a password through a limited console. A database administrator may perform specified maintenance. Very few people may enter the source code repository. A credential that opens one door does not necessarily authorise every door behind it. Kabir's old username and password may still possess technical power. The system may accept them. But technical ability is not the same as legal permission. Conversely, an unexpected result is not automatically proof of wrongdoing. A user may click a link the system itself displayed. A role may have been configured incorrectly. Authority may have been granted informally or extended temporarily. Permission is therefore a factual and legal question. We must identify its source, scope, duration and limits before attaching a legal label. Clause A of Section 43 covers accessing or securing access to a computer system, computer network or computer resource without the required permission. Episode 2 introduced the Act's broad definition of access. It includes gaining entry into, instructing or communicating with the logical, arithmetical or memory function resources of a computer system or network. So access is not limited to opening a visible folder. Sending an instruction to a system, invoking a function or communicating with a protected resource may also matter. Return to Kabir. His engagement ended on June 30th. The platform's offboarding record says that his authority ended that day, but the account was never disabled. On July 4th, the same credentials entered the support console. the login record establishes that the account was used. It does not, by itself, answer every legal question. We would still ask whether Kabir used it, whether another person obtained the credentials, whether any continuing permission existed, whether the timestamp and system logs are reliable, and what resource was actually reached. This distinction is vital. A log can record that an account accessed a system. A court must determine, on the evidence, who acted and whether the act lacked permission. Account attribution is not automatically human attribution. Clause B addresses another feature of digital conduct. Information can be taken without physically disappearing. It covers downloading, copying, or extracting data, a computer database or information from a computer, system, or network without permission. It expressly includes information or data held in removable storage media. In the physical world, theft often leaves an empty space. In the digital world, the original may remain exactly where it was, while an identical copy leaves the authorized environment. Suppose Kabir exported Riaz's scholarship file and a list of student email addresses. The database still contains both. Nothing appears missing, yet a copy may have been made and extracted, but the verbs must remain separate. Viewing a record is not automatically the same as downloading it. Downloading is not automatically the same as publishing it. Copying is not automatically the same as deleting it. And an export event associated with an account does not, without more, prove who initiated it. A careful inquiry may examine export logs, file hashes, browser artifacts, cloud activity, removable media records, network traffic, and the destination to which the data travelled. The legal proposition is simple. The evidentiary task may be complex. Clauses, Z to F, move from entry and extraction to interference with the system itself. Clause C concerns introducing or causing the introduction of a computer contaminant or computer virus. The Act defines a computer contaminant as computer instructions designed to modify, destroy, record or transmit data or programs, or to take over the normal operation of a computer, system or network. A computer virus is defined more specifically through instructions, information, data, or a program that destroys, damages, degrades, or adversely affects the performance of a computer resource, or attaches itself to another resource, and operates when a program, data, instruction, or triggering event occurs. Clause D covers damaging a computer, system, network, data, database, or program. Clause E covers disruption. Clause F covers denying access to a person who is authorized to use the resource. One course of conduct may produce several effects. A malicious instruction alters records. The altered records destabilize the service. The disruption prevents authorized students from logging in. But we should not simply collect statutory labels. For each allegation, we must ask what happened, what caused it, which resource was affected, and whether the act was performed without permission. The Act's definition of damage is also broad. It includes destroying, altering, deleting, adding, modifying, or rearranging a computer resource by any means. Digital damage is therefore not confined to breaking hardware. Changing the logical state or utility of a resource may be legally important, even when the machine remains physically intact. The remaining clauses are less frequently discussed, but they complete the structure. Clause G covers providing assistance to another person to facilitate access to a computer, system, or network in contravention of the Act, rules, or regulations. Suppose Meera, a current employee, sends Kabir an internal link. That fact alone does not resolve liability. Did the link actually facilitate access? Was the access contrary to the legal framework? What authority did Meera have? What did she do, and what did she understand? We must resist the shortcut from association to guilt. Clause H concerns charging services used by one person to another person's account by tampering with or manipulating a computer, system, or network. Clause 1 covers destroying, deleting, or altering information in a computer resource, diminishing its value or utility, or affecting it injuriously by any means. Clause J concerns stealing, concealing, destroying or altering computer source code, or causing another person to do so with an intention to cause damage. Notice the precision. Clause J expressly introduces an intention to cause damage, and Section 65 separately addresses knowing or intentional concealment, destruction or alteration of computer source code that is required by law to be kept or maintained. Similar facts may therefore require careful classification. The section number should follow the proved ingredients. It should not be chosen merely because the allegation involves code. We can now see Section 43 as a civil contravention framework. Where a person performs a covered act without the required permission, the section makes that person liable to pay damages by way of compensation to the person affected. This does not mean that compensation appears automatically whenever a system behaves unexpectedly. The claimant must establish the relevant act, the absence of permission, the person legally responsible, the injury or loss relied upon, and the evidence supporting the claim. Sections 46 and 47 then help us understand the adjudicatory structure. Under Section 46, an adjudicating officer exercises jurisdiction over claims for injury or damage not exceeding 5 crore rupees. Claims exceeding that amount lie before the competent court. Section 47 directs attention to 3 factors when compensation is quantified: unfair gain, where it can be measured, loss caused to another person, and the repetitive nature of the default. Appeals proceed through the statutory appellate framework, with the Telecom Dispute Settlement and Appellate Tribunal performing the role assigned to the Appellate Tribunal under the Act. This is an overview of the legal architecture, not advice about where or how a particular claim should be filed. The essential lesson is narrower. Section 43 identifies prohibited computer-related acts performed without permission and provides a route to civil compensation. Criminal liability requires us to cross a second legal threshold. Section 66 is titled Computer-Related Offences, but it does not create a completely separate catalogue of technical acts. It points back to Section 43. If a person dishonestly or fraudulently does any act referred to in Section 43, Section 66 provides criminal punishment. The structure can be expressed carefully. First, identify an act referred to in Section 43. Second, prove that the person performed it. Third, establish the absence of the required permission. Fourth, determine whether the act was done dishonestly or fraudulently. The current punishment is imprisonment for a term that may extend to 3 years, or a fine that may extend to 5 lakh rupees, or both. This explains why it is inaccurate to call every Section 43 incident a cybercrime. Section 43 supplies the conduct. Section 66 adds the criminal mental element. Without that additional element, the existence of a civil contravention does not by itself establish the Section 66 offence. Consider 3 situations involving the same employee account. In the first, a system administrator misconfigures a permission. An employee clicks a folder displayed on the dashboard, realises it contains restricted information, closes it immediately and reports the error. In the second, the employee knowingly exceeds a limited role, exports a customer database and gives it to a competitor for payment. In the third, the employee deletes audit records to conceal an earlier unauthorised transaction. The screen, account and database may be the same. The surrounding facts are not. The first situation is not automatically a Section 66 offence, merely because restricted information appeared. We would still examine permission, conduct, and state of mind. The second may support an allegation of dishonest or fraudulent extraction if the statutory requirements and evidence are established. The third may involve unauthorised alteration or deletion, together with evidence directed to intention and concealment. Criminal law does not punish a visual resemblance between incidents. It punishes conduct whose required ingredients are proved. A suspicious login, a copied file or a deleted record may begin an investigation. None of them, standing alone, is a complete legal conclusion. Section 66 uses two words that do substantial legal work: dishonestly and fraudulently. Its explanation refers to the meanings assigned to those terms in sections 24 and 25 of the Indian Penal Code. In substance, dishonest intention is connected with causing wrongful gain to one person or wrongful loss to another. Fraudulent conduct requires an intention to defraud. These are not decorative adjectives, they are part of the criminal offence. Evidence of state of mind is rarely found in a document labelled "my intention." It may be inferred from proved circumstances: concealment, repeated conduct, use of another person's account, diversion of information, financial benefit, deletion of logs, false explanations or other surrounding facts. But inference is not assumption. The circumstances must be proved, and the proposed inference must be legally justified. There is also a current drafting point. The Bharatiya Nyaya Sanhita replaced the Indian Penal Code as India's General Penal Code from 1st July 2024. Yet the consolidated text of Section 66 continues to contain its express reference to the former IPC definitions. A real case, therefore, requires careful attention to the statutory text, the applicable general criminal law, and the date of the alleged conduct. We should not silently rewrite Section 66 or substitute a new section number merely for convenience. Before we apply the law, we must remove one persistent source of confusion. Section 66 and Section 66A are not the same provision. Section 66 remains the computer-related offence linked to acts referred to in Section 43 when they are done dishonestly or fraudulently. Section 66A was a different provision dealing with specified online messages and expression. In Shreya Singhal v. Union of India, the Supreme Court struck down Section 66A in its entirety on 24 March 2015. The court held that it impermissibly restricted protected speech and suffered from constitutional defects, including vagueness and overbreadth. That judgment did not strike down Section 66. It did not erase the computer-related offences in Section 66B to 66F. And Section 66A cannot be used today as though it remained an enforceable offence. The difference is not a technical footnote. Confusing the two provisions can turn an accurate legal explanation into a serious error. Return to Ria's account. What can we say responsibly? The platform has evidence that Kabir's former account was used after his engagement ended. It has an export event involving Ria's file. It has records of deletion and a period of service disruption. Meera sent an internal link shortly before the activity. These facts justify preservation and investigation. They do not yet justify pretending that every disputed fact has been proved. Investigators would need to determine who used the account, from which device and environment, whether credentials were shared or compromised, what resources were reached, what actions occurred, whether permission existed, what loss followed, and what evidence supports a dishonest or fraudulent intention. Kabir's name on the account is relevant. It is not necessarily conclusive. Meera's message is relevant. It is not automatically proof that she knowingly facilitated unlawful access. The outage is relevant. It must still be connected causally to the alleged conduct. Good digital law analysis separates three layers: what the system recorded, what a human being is proved to have done, and which legal consequence follows from those proved facts. A cyber incident demands speed. Legal proof demands discipline. The two objectives must work together. Operationally, the organisation may need to secure affected accounts, contain continuing harm, restore authorised access, and protect users. Evidentially, it should preserve relevant logs, timestamps, system states, communications, access records, and forensic material through a documented process. Careless remediation can destroy the very evidence needed to understand the incident. Careless preservation can leave the harmful activity running. The response should therefore distinguish the live system from preserved evidence, record who handled each item, avoid unnecessary alteration, and obtain appropriate technical and legal assistance. A screenshot may preserve what appeared on a screen. It may not reveal the full message header, account history, source system, metadata, or sequence of events. An IP address may identify a network connection. It does not invariably identify the individual behind a device. A file hash may help test whether two digital files are identical. It does not, by itself, explain who copied the file or whether the copy was authorized. Each item answers a limited question. Reliability comes from assembling the chain without asking one artifact to prove more than it can. We can now build a repeatable method. Question 1. What computer, system, network, or computer resource was involved? Question 2. Who owned it or was legally in charge of it? Question 3. What permission existed and where did that permission end? Question 4. Which precise act referred to in Section 43 is alleged? Access, extraction, contamination, damage, disruption, denial, assistance, wrongful charging, injurious alteration, or interference with source code. Question 5. Who performed or caused that act, and how is the human actor attributed? Question 6. What injury, loss, disruption, or other consequence is proved, and how is it connected to the act? Question 7. Is there evidence that the Section 43 Act was done dishonestly or fraudulently, bringing Section 66 into the analysis? And question 8. How will the system, records, communications, devices, and other electronic material be preserved and proved? This method prevents 3 common errors. It prevents us from calling every technical failure an attack. It prevents us from calling every unauthorized act a crime. And it prevents us from treating a digital identifier as automatic proof of the human offender. Section 43 and Section 66 work together, but they do different legal jobs. Section 43 identifies specified acts involving computer resources when performed without permission and provides a civil route to compensation for the person affected. Section 66 criminalises an act referred to in Section 43 when the act is done dishonestly or fraudulently. The difference is not simply small harm versus serious harm. It is a difference in legal ingredients. We begin with the resource. We reconstruct permission. We identify the precise act. We prove attribution and consequence. And only then do we ask whether the additional criminal mental element is established. But Ria's incident has not ended. Her scholarship file has been copied. Her password has been used. A caller now pretends to be a platform official and asks her to approve a payment reversal. A private image recovered from an old device is threatened with circulation. What if somebody uses another person's password or unique identity feature? What if a phone or computer is used to impersonate a trusted person and induce a payment? What if an intimate image is captured, transmitted, or published without consent? And what exactly must be proved before Section 66E applies? Those questions form Episode 5, Stolen Identity, Online Impersonation and Digital Privacy. This is Beyond Bare Act, Law in Context, Power in Practice.